Understanding Conservatorship Part 2, Preparing for the Conservatorship Process. Hello, my name is Elvia Diaz. I am a family transition specialist at Navigating Change in San Diego State University, and I'm also a mother of a son with autism. So we are going to try to understand what to do before filing and how to make informed decisions that protect your loved one while preserving their rights and dignity. So if you saw, this is a part 2. We are going to talk about it. But before we talk about that, we would like to understand this disclaimer. This presentation is designed to help families understand the conservatorship process and prepare for important decisions. So we are trying to take away a lot of all the legal jargon, but for you to understand it better. But please remember that this is not a do-it-yourself legal guide because every family is unique. So we strongly encourage families to consult with a qualified attorney before filing for conservatorship. So with that out of the way, let's get started. What are we going to talk about? Well, as mentioned before, this is part 2 of a video. We're going to do a quick recap of what we saw on video 1. And then we're going to talk about getting the process started, maybe some emotional considerations, and what we will cover on part 3 of the video of this series. So let's remember, what is conservatorship? Well, as you already know, it is a legal arrangement where a judge appoints someone to help an adult who cannot safely manage certain personal or financial decisions independently. So the court's role is to protect the rights of the individual while ensuring their health and safety. So there are 2 types of conservatorship. We saw that in the previous video, but just so you remember, we have limited conservatorship and general probate conservatorship. So these have been explained in the previous video. Now, on this recap, we need to remember that conservatorship is not the only option. So before granting a conservatorship, the court expects families to consider less restrictive alternatives. Because as we know, the goal is the least restrictive option that still provides adequate protection. So we are going to talk about these alternatives. We saw these, we mentioned this slide in the previous video, but now we are going to go a little deeper. So let's talk about support decision-making allows adults with disability to make their own decisions while receiving guidance from trusted supporters. So that means that they appoint someone to help them make decisions. And it doesn't have to be one person. It can be different adults who can help them make information, comparing options, communicating decisions. Individual remains the decision maker. This is very important. The individual remains as a decision maker. They can only help. So in this support decision making, there's a whole presentation about this, but we wanted to consider here. The adults it is best for someone who needs support, but they have a level of understanding to ultimately make their decision. So now, educational consent form. Some of our loved ones are able to continue school, but the universities normally are bound by something that we call FERPA. That means that in the universities, me as a professor, for example, I cannot disclose information, or the administration also. No one can disclose information about the student unless the student signs an educational consent form. So sometimes our loved ones cannot go through all the legal process and all the registration and information. So they need to sign information like maybe IEP participation. Maybe, for example, if your loved one is already 18 and is still in the school district, well, you need to have a consent to participate on his individual education planning, or maybe to be able to communicate to school or education record. So it can be once they're 18, they are legally bound to their own decisions. So in this case, this is best for students who understand education decisions but want family support. So also in the other video, we talked about HIPAA, but this is very important. If you need to have HIPAA, which means authorization, release, and of the different methods. And this is, what does it mean? It means health. So this Health Insurance Portability Accountability Act is very important because you need to receive the updates or discuss treatment options or access medical records. But important, the HIPAA does not allow the parents to make medical decisions. You can only access the records. For example, maybe your loved one needs help making medical appointments. Maybe they need help asking for medication, or maybe with this, you have access, and if the doctors or they call to give information or to make appointments, they're going to ask for their name, and you're going to say, yeah, but I'm the mother, I'm the father, I'm the caregiver, and I have the HIPAA. And then they are allowed to speak to you. Otherwise, they cannot, because they're bound by confidentiality. Okay? So it is different from an advanced healthcare directive. Okay, this advanced healthcare directive allows adults to state healthcare preferences. So in this case, yes, the individual appoints someone to make medical decisions if they become unable to do so. All of us should have one of these. All of us should have an advanced health directive, because in case that we are not able to make our own decisions, we need to appoint someone. In this case, it is best for adults who can understand and sign legal documents. So they decide who can be their care directive. So let's talk about, as we mentioned before in the previous presentation, but the power of attorney is your best friend until the conservatorship becomes approved. Because once your loved one turns 18, they are liable for every decision they make, and you want to protect them. But with the adorable power of attorney, it allows the adult to authorize another person to handle maybe the bank, financial transactions, property matters, and legal affairs. So it means that you can speak on their behalf. But again, the person must be legal capacity when signing, right? So as I mentioned, in my case, my son, when he turned 18, the next day we were signing the dual power of attorney, because I needed to make sure that I could speak to the doctors and everything that his care entitles. So also you need to have a representative pay, which is normal for SSI, for example, and the Social Security Administration appoints someone to manage, all right? So this is very important. A representative pay is not the same as a conservatorship. It means that you have access to his or her financial issue. So once you become the payee, so the authority is limited to the Social Security funds only, right? Now, maybe you decide to have a joint bank account, which is okay, but it can be easy because it's easy access and you can have it on the application and you can see their funds are yours, but it can be risky because if he is not conserved, maybe your loved one can sign a contract or maybe even buy a car, and you're like, oh my God, now you have a legal bound to that because you have joint accounts. So you have to be very careful with that. Also, you might consider and look into what is a call-able account, all right? Because if your loved one is receiving SSI, there is a cap on how much they can have on their bank account. It can change, but in my understanding, it's about $2,000. If they have more than $2,000, then they stop receiving SSI. So you need to consider that. And maybe it'd be worth also research on able accounts, all right? There's able account, which helps for taxes and also helps them save money that will not work against their benefits. So what is the least restrictive option? Well, here you need to ask yourself, what support does my loved one truly need, right? Which rights can they safely maintain? What decisions can be supported without court involvement? So this is your first step, because remember, conservatorship should be the last resort and not your first step. So once you have considered all that, then you need to know what rights may be requested. So in a limited conservatorship, the court may grant specific rights to the conservator, and the family should carefully evaluate each request. Just because you ask for the right doesn't mean that the court will grant it, right? So we shared this slide in the previous presentation, but now we're going to go a little bit deeper. So in the medical consent, you have to remember that this is what you are asking, and we already talked about it with the HIPAA. And on the voting rights, this is only when they consider express preference and choices, or if there's clear evidence that the individual cannot communicate a desire to participate in voting. And residence decisions, they may allow the conservatorship to know where the individual lives. So this is very important because, of course, the family is going to consider, should they decide to go and live in supported living services in all these programs. This is important because even though they are living in assisted living or independent living, if your loved one is conserved, then if someone comes visit, they will tell you, and only if you are informed. And of course, you need to accept and give permission that the visitors who come. So you still have some level of protection, even though their loved one is living independently. So again, let me rephrase this. If they are conserved and maybe you're concerned that who comes and visit, and there are some people that may not be a good influence, then if your loved one is conserved, then the facilities and the administration will ask for permission of who can come visit. So it's to protect your loved one, right? And of course, again, we talked about the financial authority. So you need to just maybe the income benefits. Some people have living trusts. So you need to consider that. And again, I mentioned the able account. So you need to consider the support systems that adequately address these needs without the conservatorship. At this point, I'm hoping that maybe if you're here, is because you have decided that it could be your best option. Also, another right is the relationships in marriage. The court makes these rights very seriously. So, of course, this is probably one of the most difficult rights, because you need to decide if they are able not just to marry, but can they carry on the responsibilities of marriage, and making decisions, because sometimes people want to take advantage of them. So this is personal autonomy and dignity. So it's not just about, again, being able to sign a legal bounding, such as marriage, but can they carry on the responsibilities that contract entitles, all right? So again, also, there are contracts and legal agreements. Let me give you an example here. Maybe they need to sign a lease or enter contracts or make major purchases. If they are conserved and someone decides to buy a car, well, they say, guess what? My loved one is not allowed, this contract is not valid because this person is conserved and that contract becomes void. I happen to know of a situation of an individual who was working for a company, and he was very good with a computer. But then they asked him to sign a contract that was not very, let's say, respectful of his dignity. So then again, because that individual was conserved, that contract was able to become void. So that's when protection comes in. That's what conservatorship is all about. So it is important to remember that you may ask for all the rights, but the court will decide on the best interest of your loved one. If you feel that your loved one could have taken advantage of, maybe for financial situations, some of our children do not have the concept of money. They can have an idea that is just paper. They don't know the concept. I'll give you an example. My son lost his Nintendo. He's 22 years old. He lost a Nintendo. And of course, I'm like, oh, come on, this is very expensive. Well, how much does it cost? It's over $200. That's easy. $200 is $200 bill. How difficult can that be? So my job, of course, is to help him understand how difficult it is to obtain those $200. So that's when we just need to decide, and it depends on our own individuals. So now let's say you decided that, yes, I need to remember to go ahead and do the conservatorship. So you can need to assess exactly what is their daily living, on the finances, healthcare, and decision making. We have talked about that. Now let's see. You have already decided on these alternatives, and you said, yes, I know. Now, conservatorship is my next step. Right. So what to do next? Well, here comes where the family or next most important support system need to come together. So you need to discuss together your goals, expectations, future planning, and roles and responsibility. Now, as a mother, I know that normally our support system is very close, not too many people, okay? But this is why I know that as a parent, probably one of our biggest fear is what's going to happen when I am not living. So what would happen to my loved one? So here's when we need to provide, that is us plus another person who will provide that support, who will serve as a backup, who will be, the decisions can be communicated. How would you decide all that? All these, you need to sit down and maybe draft it and then talk to the loved ones who will be the support system. Now, in this, once you need to decide who the conservator or co-conservators can be, because it needs to be someone that is trustworthy. They must be organized, patient, willing to advocate, and able to fulfill ongoing responsibilities. Now, when we say trustworthy, of course, please do know that you will have your background checked. So if you happen to have some legal issues background, well, it'll come up. So it is important to remember that just because someone is a loving parent, that does not automatically mean that they're going to be the best conservator. So again, let me emphasize that you can have co-conservatorship. So normally they mention no more than 3. In my case, it is myself and his sisters, my daughters, who will be there, my son's co-conservator. So it is very important that once we go through the process, it's not only up to you, and your loved one will be taken care of even when you're not here anymore. So, and the responsibilities, well, of course, we will need to attend the hearings, maintain records, submit reports, communicate with agents, protect their rights, and advocate for services. So these are going to be the most important responsibilities. And of course, we don't mention, but love is very important. There is a timeline But in the timeline, we don't mean that it's part 1, 2, 3, 4. So here, again, as we mentioned at the beginning, the Legal Aid Society will provide with a timeline. If you go to the web page, they have a very good timeline, and not everything is a step by step. So several processes can be happening at the same time. And when I was talking to Moira from Exceptional Family Resource Center, she said something that made a lot of sense, because this is meant to be a thoughtful process, not a fast process. Why not? Well, because we are discussing the future of our loved one. So I know that the legal process can be very daunting, but at the same time, it will give you peace of mind at the end of the day. So this is what's going to happen. Let's talk about it one at a time. So you're going to file the petition, and then there is a capacity assessment, which is medical, and also the San Diego Regional Center will be requested to complete certain forms, and then you need to serve the required parties. By the required parties, for example, if you, like in my case, my son's father does not live with us. So regardless of where that person is, whether he's in Mexico or in any other country, they need to be served. So you need to send the notification via mail, and you just have to prove that those people have been notified. So if they once they're served, usually is the father, or the mother, and aunts, direct aunts and uncles, and also the grandparents if they're still living. And then the court runs the investigation, and they will appoint a day for the hearing. And then, of course, the judge makes a decision. And there are ongoing reviews and reporting. Okay, I have been told that sometimes the investigators will come to your house unannounced, and they just to see what the potential conservatee will be living. Okay, so this process is, again, not linear. It can be circular. Several things can be happening at the same time. So once you go to legal aid and you ask them for the package and it's complete, then they will appoint your date, and that's when you need to start being very attentive to that. So here I want to mention that it can be emotionally very stressful, because sometimes mental health can suffer because it's not something that we planned for. It's not something that we wanted for our child or for our loved one. And this process sometimes can be anxiety, guilt, and sometimes, of course, relief. Why not? But of course, uncertainty. And please remember, these feelings are absolutely normal, because conservatorship is not about taking the rights away. The conservatorship is about creating the right balance between protection and independence. So it's okay, breathe, talk to your system, and just know that there are several agencies that are willing to help, like Legal Aid Society. And for this, I would like to invite you to maybe, before you start this process, you go and do this reflection activity, first with yourself and then with your support system. What are your greatest concern about the loved one's future? Which decisions can they make independently today? Which decisions may require support? What rights are most important to preserve? So once you talk about this by yourself, write it down. I'm a very important fan of even a journal. Write it down. And once you have it written down, then you can invite the support system to discuss this. So you already have proposed agenda of what is going to happen. So what are the key takeaways? Let's remember that conservatorship is one option among several, and you need to carefully consider each right that you're going to request. You need to seek legal guidance. Please don't do it by yourself. And you need to explore the less restrictive alternatives, engage your family in planning, and focus on preserving dignity, autonomy, and the quality of life of your loved one. So if you have questions, maybe we can help, but most importantly, we recommend that you contact Legal Aid Society. And we will have another video in which we will discuss the packages, which is very daunting. And for myself, probably the most stressful part, which forms are which. And again, Legal Aid will help you do it, but it's best if you know what is happening, all right? And so we will talk about how to prepare for the hearing and what to expect on the hearing day. So we are here to help you have this process the least burdensome possible. So thank you. And do remember that the goal is not simply to protect our loved ones. The goal is to help them live the most independent, meaningful, and self-directed life possible while assuring their safety and well-being. So thank you for listening, and we hope this was very helpful for you and your family. Thank you for being here.